We are here because the court, you guys came before me, I ruled, we sent it up to the Court of Appeals. And the Court of Appeals, despite the fact that there is I think a hyperlink in my order to the Court of Appeals that links directly to the database that houses the municipal code. Instead of saying that it wasn't in the record and then could you please put it in the record, they decided to write a whole opinion saying that it wasn't in the record. And so the question I have for y'all is the answer, let's certify them and put them in the record and send it back to the panel from the Court of Appeals, or is that not the answer? Or do we need more time to figure out the answer, Mr. Cook?
I mean, Your Honor, our position is the case is over. I would emphasize the lack of a remand language in the Court of Appeals opinion. They simply vacated this court's final order without further instructions, did not remand for further proceedings or for supplementation of the record or other instructions to the trial court. I would point out that when Georgia appellate courts intend additional proceedings on remand, they ordinarily say so expressly. And I cite the Doxley versus Chrissy court opinion of 359 Georgia App 190, which says where the appellate court intends additional action, it expressly remands for further proceedings on that issue. Had the Court of Appeals intended supplementation, it would have said so in its opinion. Since the ordinance was not part of the properly before the Court of Appeals on appeal, it was also not part of the record on the Superior Court and in the BZA hearing. Therefore, the zoning board was not in a position to sustain the violation. The entire process below is defective and ineffectual, and therefore this matter is concluded. The Court of Appeals simply vacating the final order with no further instructions, the Superior Court cannot now supplement the record with the ordinance that was not before the zoning board in the proceedings below. Our position is nor can the court order the zoning board to supplement the record. The zoning board conducted the hearing below. It had its opportunity to present its case and it failed. They had their chance, and this case is now closed. That is our position. If you're inclined to open up the case for supplementation, I have further argument which I'd like to be heard on, but I'd like to simply state that that is our position presently.
Understood. Thank you, Mr. Cook. Ms. Evans?
Thank you, Judge, and good morning. I just wanted to let the court know I've got Ryan Harbin with me in my office, and also George Prothero from the city in-house attorney is here as well.
I recognize Mr. Prothero. I see him a good deal on any number of cases. So
good morning,
perfect.
Judge Cross.
Old friends. Just a little housekeeping thing, and I'm sure I know Mr. Cook just got here, but we did not receive any copy of any request for continuance. I appreciate the judge didn't grant it, but we would appreciate Mr. Cook including us on any communications any requests that he makes, particularly so that we could weigh in. And if there was any argument, we'd like to have a copy of that just for the completeness of the record.
I would say that was an inadvertent error, and I do apologize if you were not included.
Yeah, we were not. On your question, Judge, the Court of Appeals did exactly what you said. And even though the city of Atlanta is not the one that asked for the appeal to the Court of Appeals, the city of Atlanta is not the one that asked for the appeal to Your Honor. The city of Atlanta is not the one that asked for the appeal to the BZA. The burden at every step, this one, the Court of Appeals, this one, the BZA, has always been on Tokyo Valentino. And to the extent there is any problem with the record, it is theirs and not ours. But I will say very briefly, the BZA does not have the same rules of evidence that this court does, or that the Court of Appeals has to abide by, and its rules allows them to recognize matters that perhaps wouldn't be allowed in the trial court. But also there is it is the city, and it is their ordinances. And so there's that argument that the BZA needed some certified copy of the ordinances was never made. And even though Mr. Cook is new, Tokyo Valentino is not, and it was always their burden. Now, it was also their burden to put it in front of Your Honor. And so I do think Your Honor would be within your rights to dismiss Tokyo Valentino's appeal completely, which would mean that the BZA's order would stand. But I recognize, the city recognizes that this new lower adjudicatory appellate system that the General Assembly established specifically has the intent from the General Assembly that appeals not be disposed of or ruled upon on procedural matters or for defects in the record, and that the court do everything it can really to issue an order on the merits. And so because of that, and even though it's not our burden, the city is prepared. Right now, we have the certified copies of the ordinances prepared. We can file those on the record today if it would please the court. And then we would submit that if the court satisfies itself that those certified copies look exactly like what we briefed the ordinances to say, that the court could reissue its opinion. And then if Tokyo Valentino wishes to seek an additional discretionary appeal, they can do so. And then the Court of Appeals will do with it what it will. The overarching concern from the city, Your Honor, is that further delay serves only one party. While this matter is on appeal, the rules do not allow, the law does not allow the city to enforce its zoning decision. And so as long as this is on appeal, Tokyo Valentino gets to continue terrorizing the neighborhoods around it. It gets to continue to thwart the zoning rules of the city, and the city can do nothing about it. And so I'm not surprised to hear Mr. Cook come in today and have all these new grand ideas about how we might delay things, because that only serves them and not the city. And so I would just really beg the court to move this as expeditiously as we can. And I think us filing the certified copies of the ordinances will allow us to do so.
So here's my thought, which is a couple of things. One, I think that it does need to be handled expeditiously, which is why, I mean, frankly, I was aware of this ruling probably 2 weeks before it actually got finalized as a remittitor. But I have made the mistake of jumping the gun and setting a hearing before the parties actually know that what's happening, or before it's made a final decision of this court on remittitor. And so I don't have a problem expediting it. I think that makes sense. I do think that filing the relevant municipal codes that the court was dealing with into the record, certified as they should be, makes sense. I think Mr. Cook's point, though, about what does that mean and what does it procedurally mean to the outcome of the case is a valid one. And so what I think I would like to do is hear from the parties a little bit on that topic, because what I've heard from the two of you is a wildly divergent set of circumstances. And of course, my, split the baby approach really wants to be like, well, wouldn't it just be easier to send this like, hey, Court of Appeals, here's the certified copies. Y'all do with it what you will. But I hear the city of Atlanta telling me, well, in theory, it was the petitioner's obligation to put this into the record, and therefore there would be a basis to dismiss the appeal entirely. Therefore, the BZA decision stands. And I hear the petitioner telling me essentially the exact opposite. And then in the absence of an affirmance, that given that the Superior Court's decision affirming the BZA has been vacated with no remand for further proceedings language in the opinion, what does that mean to the BZA opinion? Yes.
And Judge Krause, I apologize, Your Honor. I meant to also respond to Mr. Cook's statement that somehow we have to start all over. And I just wanted to point to the court to Kirkland versus Southern Discount Company, 187 Georgia App 453, that when you have a vacator of an order, all it does is put the parties back in the exact position they were before that order, which was the briefing was done, and Your Honor could, ask for example, these certified copies to supplement the record, which is what the lower adjudicatory statutory scheme really begs for and calls for, is that you have a hearing, order on the merits, which is what that would allow.
And here's the only reason that I am pausing on this at all is that, of course, it does occasionally occur that the Court of Appeals of the Supreme Court will remand a case for us to perfect the record with something that was clearly referenced and everybody expected to be in the record, but was not placed into the record. They send it back, we place it in the record, and we send it right back to them. And that's not what this panel of the Court of Appeals ordered me to do. And they could have without issuing a formal written opinion, but they chose to do it this way. And so I don't think that the filing of the certified copies into the record by the city changes the procedural outlook in any way right now. I think that makes the most sense to go ahead for the city to do that, number one. But number two, I do think some briefing about what does the Court of Appeals choice to enter an order rather than simply saying, hey, judge, there's a procedural defect in the record. You clearly considered things that were not properly made part of the record, but clearly were before you, which they know how to do because they do it pretty frequently. They didn't do that. They chose not to do that. And they also, to Mr. Cook's point, even if I agree with you, Ms. Evans, that a vacated order simply places the parties back in the same position they were in, which here, right, if you vacate my order, then what you have left is the BZA's order. But Mr. Cook is not wrong that the opinion did not say vacate and remand for proceedings consistent. And so I would like to do it on a very abbreviated timeline, but I do think that allowing some briefing on this issue would be helpful. What I was thinking was something like 20-ish days for the parties to send me some briefing that talks about what they think the court can or should do relative to the status of the case now that the Superior Court's opinion has been vacated because of the absence of the certified copies of the municipal code that was at issue. And that would be, I don't necessarily think that it needs to be a, here's my argument and then I get to respond. I think it's both of you already have sort of a set position. So I feel like we can just have briefing due on the same day. And if anybody feels really strongly that they need to respond to it, then y'all can let me know and I'm happy to let somebody briefly respond. But what I was imagining is that you guys could provide me with some briefing. Again, I'm not asking for you to, write me a treatise on appellate procedure, but something very targeted on this particular issue. And at 20 days, we'd be looking at the 26th, which is Tuesday after Memorial Day.
That
No,
works for
that's
us,
only
Your
10
Honor.
days. Sorry, I've got my dates mixed up. It would actually be closer to the 3rd of June, which that would be 20 days.
That
Thoughts?
works for the city, Your Honor. Thank you so much.
Mr. Cook?
Yes, that works.
Okay. And so, like I said, what I'm really looking for is just the parties' respective positions on what the effect of that ruling is if, as is going to happen because I've instructed Ms. Evans to do so, the city of Atlanta is going to, if the record can be perfected, right? The city is going to perfect it by filing certified copies of the municipal codes. And beyond that, we will see what you guys think about what the court should do and what it means for the parties' respective procedural posture or positions. Anything else? Any questions for me in terms of what next?
My only question is if you're going to open it up and allow the city to supplement the record to correct essentially a defect, are you going to allow us to supplement the record as well? Because we were prevented in the action below from submitting a lot of evidence showing that the booths were not in place at the inception. And so that's never been part of the record. And so, may we supplement the record as well?
No. And let me tell you why. I understand that the Court of Appeals is treating the existence of this municipal code as a piece of evidence that the court is apparently not allowed to take judicial notice of, and that has to be placed into the record as a piece of evidence. But it is distinct from a revisiting of original offering of evidence that can, should, would have been in front of the BZA that was not before me. And the role of the Superior Court in considering a ruling of the BZA is very limited, right, to the record that existed before it. And so the court is not going to reopen Pandora's box on that issue. My perspective, my read on this, right, wrong, or otherwise, is that this is a limited procedural issue that we need to figure out what to do with this case next. And there may be a time, Mr. Cook, if y'all persuade me that this goes back to BZA, right, then there may be a time and a place for you to present that evidence, but it's not here and it's not now. Any other questions?
I don't have a question, Your Honor, but, well, I guess it sort of is a question. The city has offered to put the certified copies on the record, really to do this as quickly as possible with, we came in with the hope that it would just lead to, confirming that the code says what it says and having an order. I just want to make sure that I preserve for the record, it is not our burden to put it in. It is and always has been Tokyo Valentino's burden. We are doing it for, really just to try to expedite the case. And so because of that, I just want everybody to be clear on that. And if there's some reason that, given that, we should wait, we're happy to do that. I just don't want to undertake a burden that's not ours, and that somehow be used against the city in the future.
And I'm not intending to create or place any burden on anyone. That's why I want the briefing, because to me, I think it makes sense for the copies of the municipal code that was considered by the court be placed into the record. Because the court clearly did consider those municipal code sections that were at issue. But to the extent that the city's position, as I understand it, is going to largely be, it wasn't our burden, and whether the codes are there or not, even if the codes are, perhaps support the city's position, right? Ultimately, if the judgment is vacated, right? If the Superior Court's decision affirming the BZA is vacated, then the BZA decision, apparently, according to the city, stands, right? And we'll have to discuss what that means. And that's why I want the briefing, is for y'all to tell me what procedurally is left for this court to do with the case, other than, like I said, one option is enter a new final order based on what the court previously found substantively, but with the presence of the municipal code, and then the parties can take whatever action they want, i.e. a potential appeal or otherwise. Or if the parties want to persuade me that something different needs to happen, that's what I'm looking for in that briefing, is what procedural step the court should take next, or should consider refraining from taking because it wouldn't be appropriate legally. Does that
Understood.
make sense?
Yes.
Mr. Cook, anything else, sir?
No, Your Honor.
Okay. Well, thank you all. That was thankfully a quick status conference. I will look for your briefing on, to be clear, June the 3rd. I'll say it again since I said it wrong the first time. I would be looking for the parties' briefing on or before June the 3rd, and I will endeavor to get you a ruling based on that as quickly as I can after that, so that we don't delay unnecessarily. Okay?
Thank you, Your Honor.
Thank you all. Have a good day.
All right, thank you.
Thank you, Judge. Have a great day.
Mr. Thompson, Mr. Bowman.
Yes, good morning.
Good morning. Mr. Bowman, are you there? There. Oh,
Yes,
sorry.
John. Good morning.
I always laugh when I catch lawyers in the car. It's this day
Yes.
and age with Zoom. It is very interesting.
Yes, and just to let you know, I am parked in a parking lot. I'm not on the road. So
Thank you. I appreciate that. That's my only hard stop, is like, don't be driving while we're trying to do this.